be doing the moderating today. He is a partner with White & Case at the firm's Washington, D.C. office. He's also, we're proud to say, a member of Washington Legal Foundation's Legal Policy Advisory Board. He clerked for the Honorable Walter K. Stapleton on the Third Circuit and the Honorable Federico Moreno of the Southern District of Florida. He returned to White & Case in 2004 after serving as counsel to the Assistant Attorney General in charge of the Antitrust Division at Justice. Eric?
Thanks very much, Glenn. Let me add my welcome to all of you here with us in person and watching via webcast. We've got a really terrific panel of experienced Supreme Court litigators with us today, and I'm sure they'll have some very interesting insights to share about the coming term. Before introducing them, if I could just take a moment to say what a pleasure it is to be part of this program again. I've worked with the WLF on numerous projects and initiatives over the years, and I feel like I grew up reading all of those advertorials in the New York Times. But the WLF's mission of defending our free enterprise system and advocating for limited government and individual and business liberties is perhaps most uniquely served as a litigant. In recent years, WLF has participated in hundreds of court cases and regulatory proceedings, including scores before the U.S. Supreme Court. I think I'm right in saying that the WLF has been recently credited as participating in more cases at the certiorari stage that were actually taken by the court than any other organization. For this term, I just want to highlight one example of the WLF's advocacy. Next week, the court will hear argument in Jennings v. Rodriguez, an important case on whether aliens subject to mandatory detention must be afforded bond hearings with the possibility of release in the United States if detention lasts more than 6 months. WLF was the only organization that supported the government's position and represented 31 members of Congress on the WLF's brief. This is the second time the case is coming before the court after being argued last term in front of 8 justices without Justice Gorsuch. True to its mission, the WLF is also the only organization I know that works hard to keep programs like today's focused on the cases on the court's docket that are most relevant to issues of free enterprise, individual and business liberties, civil justice, and limited government. With that, let's turn to our panelists, each of whom will present for about 20 minutes, followed by an opportunity for those of you here and watching via webcast to ask questions of them. Our first speaker will be Andrew Pincus, to my right. He's a partner at Mayer Brown here in Washington. He formerly served as an assistant to the Solicitor General and as general counsel of the Department of Commerce. Andrew co-founded and serves as co-director of the Supreme Court Advocacy Clinic at Yale Law School. Our second presenter will be Allison Ho. Allison is based in the Dallas office of Morgan, Lewis & Bockius, where she co-chairs the appellate practice. Allison clerked for Judge Wiener of the Fifth Circuit and Justice O'Connor. Allison also served as a special assistant to President George W. Bush and as a counselor to the Attorney General of the Department of Justice. Jeff Lampkin will be batting third. Jeff is a partner at Molo Lampkin LLP here in Washington. Jeff has served as an assistant to the Solicitor General and as a law clerk for Judge Kaczynski on the Ninth Circuit and for Justice O'Connor. So with that, Andrew, you ready to lead us off?
I am, thanks. And thanks very much to WLF for inviting me. It's always a terrific panel and a terrific discussion in these Supreme Court previews. I want to start by talking about the arbitration cases that are before the court this term. They're going to be argued first case up at 10 o'clock in the morning on the first Monday in October. And probably the most consequential arbitration issue to come before the court in the last 4 or 5 years. Maintaining arbitration as a fair and efficient and accessible alternative to the complicated and overcrowded court system has been a priority for WLF. And eliminating arbitration has been a top priority for the plaintiffs' bar. It's not surprising, and it's pretty easy to understand the difference. Arbitration is accessible to clients, injured people without a lawyer. If they so desire, they can use a lawyer if they choose, but it doesn't have the complicated rigmarole of the court system, which really only lawyers can decipher. And it's quicker, it's more efficient, and it gets justice to more people in a quicker way. Just to give an example, in the real world, arbitration today in the consumer and employment context can be filed over the internet. In most cases, the employee or the consumer can choose whether to just have their case determined on the papers they submit, to have a hearing over the telephone, or if they want to appear in person. Contrast that with the court system and the very complicated rules and the necessity of appearing in person, impossible for most real people who actually have jobs that they have to be at during the day and can't wait for a case to be called in a courtroom. As a result, arbitration has grown in popularity in the last decade or so. And with that, the plaintiffs' bar's attacks on arbitration have grown tremendously, seeing it as really cutting into their business in the most real sense of the word. As a result of that, perhaps, or maybe just coincidence, the Obama administration issued a large number of anti-arbitration regulations. Just to think about the number of agencies that did so, the Department of Health and Human Services issued a regulation about nursing homes. The Department of Education issued an anti-arbitration regulation. The Department of Labor did. Even the Department of Defense issued an anti-arbitration regulation. And of course, most well-known, the Consumer Financial Protection Bureau, just this past July, weirdly, long after the administration changed and a new president took office, issued an anti-arbitration regulation that the new administration has asked Congress to invalidate because it doesn't agree with them. This first argument of the term involves one of those anti-arbitration approaches, this time issued by the National Labor Relations Board. And just to frame the question at the beginning, it's whether it is an unfair labor practice to include a class action waiver in an agreement to arbitrate that's part of an employment contract. Many people, when they hear NLRB, think, well, that's only about union contracts. That doesn't affect most employees. Not right. The NLRB has jurisdiction over most every employer in this country except for very small businesses. So this rule, if it were adopted by the Supreme Court, would invalidate arbitration clauses in tens of millions of our arbitration agreements around the country. The Supreme Court in 2011 held in a case that I had the privilege to argue, AT&T against Concepcion, that the Federal Arbitration Act preempts a state law that invalidates arbitration agreements with class waivers. The court said class waivers have to be enforced under the FAA because the FAA guarantees arbitration in its traditional form, which has always been one plaintiff, one claimant, and one defendant, claim by claim. The NLRB in 2012, shortly after the Concepcion decision, ruled that it's an unfair labor practice to include a class waiver in an employment arbitration agreement, relying on Section 7 of the NLRA. And I want to just quickly recite the statutory language because I think it's very telling. The relevant portion protects the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and this is sort of the magic language on which this case turns, to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. What the NLRB said is that last phrase, other concerted activities for the purpose of other mutual aid or protection, includes filing class actions in court, and that therefore taking away the right to file class action violates the NLRA, and it said the Federal Arbitration Act doesn't bar the application of the NLRA to invalidate all of these many, many millions of arbitration agreements that have class waivers. The problem with that analysis is that the Supreme Court has held that the Federal Arbitration Act applies to federal laws in the same way as it preempts state laws. In other words, what the court has said is that the FAA creates a general presumption that arbitration agreements will be enforceable under federal law, and that for a federal law to overtly indicate its intent to displace the FAA's ordinarily applicable rule. Section 7, language I just read, doesn't mention arbitration, doesn't even mention suing in court. Falls far short, in my view, and I should disclose I filed a brief for the Chamber of Commerce in this case, so I may not be the most neutral observer, doesn't come close to showing that Congress intended to displace the FAA. The opponents of arbitration, perhaps recognizing that they don't have the strongest argument under the line of cases that I just finished talking about, really rely principally on two other arguments. First, they say that the National Labor Relations Act, Section 7, the language I quoted, confers a substantive right, and that substantive rights are protected without regard to this FAA presumption. To me, the problem with that argument is, and the court has said this in other contexts, the substance procedural distinction really doesn't have much content. It's much more a label after you decide what you're going to do, as opposed to something that gives you much guidance in the first place. And it's awfully hard to see when the Supreme Court has said, for example, that Rule 23 is procedural, and it has had no trouble in other statutes that create causes of action saying that language about filing in court doesn't displace the FAA. It's hard to see why this language should be treated any differently. Opponents of arbitration also rely on the FAA's savings clause. Section 2 of the FAA, after saying that arbitration agreements generally should be enforceable according to their terms, says, save upon grounds as exist in law and equity for the revocation of any contract. So generally applicable contract principles also apply to arbitration agreements. What you can't do is have a special rule that targets arbitration agreements for invalidity. The NLRA's argument here is, well, Section 7 makes contracts with class waivers invalid and illegal. Illegal contracts are unenforceable, so we're just seeking to apply the general contract rule that illegal contracts are unenforceable. Again, a big problem. If that's enough to override the FAA, then if you're a state that doesn't like arbitration, like the state of California, all you have to do is pass a state law that says the same thing as the NLRA has said. No class waivers in arbitration agreements. Any arbitration agreement that has a class waiver is illegal and unenforceable, and that, under the NLRA's theory, would also provide for the invalidation of arbitration agreements. But that's exactly what California had said, albeit by common law, not by statute, in the Concepcion case, and that's exactly what the Supreme Court said was preempted. So I think there's a big problem with that argument. An interesting thing about this case is a change of position because after the new administration took office. There are three cases that the court has consolidated. Two of them involve private parties on both sides. One of them involves a petition for review of an NLRB decision that applied this rule to invalidate an arbitration agreement, a company called Murphy Oil. The Solicitor General, before the change of administration, filed a cert petition seeking review of the lower court decision in the Fifth Circuit to not enforce the NLRB's decision. That case was granted along with the other two, but when it came time to file the merits brief, the Solicitor General's office gave the NLRB the authority to continue to argue the case, but filed an amicus brief disagreeing with the NLRB's substantive position. I think Supreme Court watchers know that's hardly an unprecedented situation. At the change of administration, there always is a little shifting, especially when independent agencies are involved, because there's a lag time before those agencies catch up to the new administration's positions by dint of changes in their membership. I mean, interestingly, just this past Monday, the final open seat on the NLRB was filled, now has 5 members. It'll be interesting to see, maybe we won't find out before next Monday, whether the NLRB itself still agrees with the position that its general counsel has been arguing on its behalf in the Supreme Court. Let me turn from arbitration to talk about another case that's similarly been a long-running battle, mostly fomented by the plaintiff's bar, and that's a case involving the Alien Tort Statute. The ATS, as people who have watched and been involved in WLF knows, is a statute that was enacted in the Judiciary Act of 1789. It confers jurisdiction on the federal courts for claims brought by aliens, torts in violation of international law, and it slept silently until the late 1970s, when the Second Circuit said, oh, this isn't just a statute that provides jurisdiction for claims that are otherwise authorized by some other body of law. this creates a common law remedy, and it's a common law remedy that can be used to litigate in U.S. courts claims about alleged human rights violations that occurred anywhere in the world. So with that opening gun from the Second Circuit, the game was afoot, and there were a large number of ATS cases brought in U.S. courts. Some, a very few, like the case that the Second Circuit, involved claims against actual perpetrators of human rights violation, people who tortured or did other terrible things in foreign countries. But most claims, perhaps because there wasn't a lot of money in those claims, ended up being brought against U.S. and foreign corporations, not on the theory that they themselves violated international law, because there are very, very few international law norms that apply to private parties, but on the theory that they somehow had aided and abetted or conspired with government actors in countries around the world to perpetrate these violations. Obviously, these lawsuits are a public relations nightmare for any company, no matter how unjustified they are. No one wants to be accused of being a human rights violator. And as we all know, it's pretty easy to make an accusation, much harder to rebut it, especially with respect to events that occurred somewhere around the world a long time ago in many cases. So this litigation grew and grew. The Supreme Court's first interaction with it was in a case called Sosa, in which the ATS claim was dismissed, but there was a division on the court. Justice Souter, writing the controlling opinion, said, we're going to open the door, we're going to reject the government's argument that this is just a jurisdictional statute and it doesn't create a cause of action. We're going to hold there is a common law cause of action here, but only for a very, very small, limited number of torts that resemble the things that were actionable at common law in 1789, like piracy. Justice Scalia wrote a prescient concurrence saying the majority says they're just leaving the door ajar a bit, but that door is going to be kicked open and this will not do anything to dent the abuse of this statute. And Justice Scalia proved totally correct. Sosa didn't do anything. The lower courts continued to uphold these cases. Then the court heard a case called Kiobel out of the Second Circuit, in which the Second Circuit had held another case involving alleged human rights abuses in a foreign country with the corporate defendant being alleged to be an aider and abetter. The Second Circuit said there's no corporate liability under the ATS. There's no basis either in international law for corporate liability, and therefore corporations can't be sued. The Supreme Court granted review, heard argument, and then asked for re-argument on a separate question: does this statute have extraterritorial effect? Addressed that issue, held that it didn't, and therefore that the alleged claim had to touch and concern, the magic words, the United States, in order for it to be actionable under the ATS. As a result of that decision, some, but not all, of the abusive ATS litigation was curtailed, but some continued. The Jesner case, which is the case that is before the Supreme Court now, in the Second Circuit, brought against the largest bank in the Middle East, the largest bank in Jordan, Arab Bank, very significant to the Jordanian economy. And the Second Circuit adhered to its view in this case that corporations aren't liable, declining to address the many other arguments for non-liability, including including extraterritoriality, lack of proof of aiding and abetting, all kinds of things. The court decided to rest on corporate liability in an interesting opinion where the panel said, we're bound by this Second Circuit precedent, but we really, really, really don't like it. The Second Circuit didn't grant rehearing en banc. The Supreme Court granted review, and so here we are, the case back before the Supreme Court on the question of is there corporate liability under the ATS, vigorously contested. As I said, most of the international norms at issue apply to government actors, not to private parties. Most liability for private parties under international criminal law, which is most of these norms are criminal norms, is limited to individuals. At Nuremberg, for example, which is sort of the font of international law, there was no corporate liability. So the questions in this case are, first of all, what law decides? Is this a federal common law question about who's liable? Is it governed by international law? And under which either of those, what is the right answer? It's an interesting situation for a court that has really eschewed in the last 20 years any kind of federal common law rulemaking, except in very limited areas like admiralty, to be faced with having to make the policy decisions about how broad liability should reach, but that's the question that the court will have to decide. I should say that the respondent, Arab Bank, in the case, has also urged the court to focus on the lack of, on the extraterritoriality of the claim, and to said that that's certainly an alternative ground for upholding the dismissal of the claim if the court decides to not reach the corporate liability issue or decides the corporate liability issue in a way different than the Second Circuit. But I will stop there and look forward to my co-panelists' presentations and some good questions. Thank you.
I'd like to begin by echoing Eric's comments about what a great privilege it is to be here today at the Washington Legal Foundation, which has done so much to advance, to carry the torch for free enterprise, the free enterprise that has made our nation the greatest country on earth. So thank you for the opportunity to be here and also to have the opportunity to present today with my fellow distinguished panelists. I'm going to highlight the Oil States patent case, and at the outset, in the interest of full disclosure, I want to make clear that I represent Oil States as counsel of record in the Supreme Court, along with Eric Hawes, my colleague and intellectual property litigator, and Judd Stone, an appellate litigator and former law clerk to Justice Scalia. One commentator has described Oil States in very low-key fashion as just the most important patent case in modern history. So with that set up, the question presented in Oil States is whether an administrative proceeding called inter partes review, or IPR, established by Congress 6 years ago in the America Invents Act to adjudicate the validity of patents, violates Article 3's separation of powers principle or the Seventh Amendment's jury trial guarantee. Oil States implicates two larger trends that court watchers have been following for some time. First, the Supreme Court's increased involvement in the development of patent law itself. And second, the Supreme Court's growing unease about the rise of the administrative state, which WLF has also played a leading role in that movement as well. So as to the first trend, in the last several years, the number of patent cases decided by the Supreme Court has greatly increased. And to give you some perspective, historically, the court decided about one or two patent cases a year, and none at all in some years. Now, the court typically hears and decides 3 to 4 cases a year, and last year it decided 6 cases involving patents. In one of the biggest patent cases decided last year, T.C. Heartland, in which the Washington Legal Foundation filed a very important amicus brief, the Supreme Court unanimously rejected rules governing where patent cases can be brought that the Federal Circuit had been applying for decades. T.C. Heartland has already reshaped the landscape of patent litigation in the United States. In less than 6 months since it was decided, the Eastern District of Texas has lost its perch as the most frequent federal forum for patent suits, with the majority of suits now filed in the District of Delaware and in California. Commentators have advanced various theories about the reason for the increase in patent cases at the Supreme Court, but I think regardless why the court is taking on more patent cases, as it decides more patent cases, it naturally gets more comfortable in doing so. And as a result, I think we can expect that trend to continue. This year, there are already 2 patent cases, including Oil States, on the docket, and more may be added over the course of the term. As for the second trend, at least 5 of the current justices have expressed a willingness to at least reconsider some of the pillars of the modern administrative state. Most notably, the doctrine that courts should generally defer to agencies' interpretations of their own regulations, known as our deference, and the doctrine that courts must accept agency interpretations of statutes as long as those interpretations are reasonable, or Chevron deference. And these concerns about the rise of the modern administrative state have focused to a large extent on separation of powers, that it is the province of the legislative branch to make the law and of the Article III judiciary to say what the law is and to exercise the judicial power of the United States. As Justice Thomas put it in his concurrence in Mortgage Bankers versus Perez concerning judicial deference to agency interpretations of their own rules, and it's well worth quoting in full, quote, "The agency, as part of the executive branch, lacks the structural protections for independent judgment adopted by the framers, including the life tenure and salary protections of Article III. Because the agency is thus not properly constituted to exercise the judicial power under the Constitution, the transfer of interpretive judgment raises serious separation of powers concerns," close quote. And that's precisely the Article III issue in oil states. Whether in creating inter partes review, Congress has impermissibly transferred from Article III courts to an executive branch agency the ability to adjudicate patent validity in adversarial proceedings that the agency itself calls trials that result in final judgments, thus offending the separation of powers by impermissibly allowing an administrative agency to exercise the judicial power of the United States. More specifically, without getting too much into the weeds, if one can do that in a patent case, the America Invents Act, which was signed into law in September of 2011, created the Patent Trial and Appeals Board, or PTAB. I think everything has to have an acronym, right? It operates within the Patent and Trade Office, and it vested the board with the authority to conduct adversarial proceedings between private parties to adjudicate the validity of already issued patents, including patents such as the one at issue in oil states that had been issued more than a decade before the America Invents Act. The board comprises judges who serve at the pleasure of political appointees and are employees of the executive branch. The executive branch's political appointees appoint these judges without the Senate's approval. These appointees have no protections against being fired other than ordinary civil service laws, and they depend on executive branch officers to receive raises and promotions. And basically one way to think about it is just PTAB judges are the opposite of Article III judges, where Article III judges are chosen by the president and confirmed by the Senate for life. PTAB judges are selected by a political appointee and then subject to that appointee's approval for promotions, raises, and retention. For those of you who are Declaration of Independence buffs, this is exactly the founders' complaint about King George. I quote, "He has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries." I somewhat doubt that the founders would have been less disturbed if, say, a minister of King George had done the same rather than the king himself. And the separation of powers concerns with inter partes review are not just academic. As Justice Thomas explained in his Mortgage Bankers concurrence, Article III's requirements of life tenure and salary protection are structural protections of independent judgment. The Patent and Trademark Office has admitted that its director has selected administrative patent judges who enjoy neither life tenure nor salary protections for expanded panels with the express intent of ensuring the ruling desired by the director. And that is, the director has intentionally selected judges who will reach the opposite conclusion from the judges originally assigned to a case, so that the expanded panel will achieve the director's desired result. The director refers to this as case-specific re-adjudication. In addition to the Article III issue, oil states also presents a Seventh Amendment issue, that is, whether inter partes review not only violates Article III by allowing an executive branch agency to exercise the judicial power of the United States, but additionally offends the Seventh Amendment by permitting an executive branch agency to decide issues that historically would have been decided by a court at law. So for a little segue into some federal courts background, for the most part, only the federal courts can hear cases in the federal government. That's the general rule. There are a set of cases where Congress can decide just to deal with the issue itself or give the cases to an agency. And these are so-called public rights. You may have heard this term discussed in connection with the case, the public rights doctrine. These cases involve, for example, suits against the government itself. And that's why we have an Article I Court of Claims. But these cases are the exception, not the rule. In a 2015 case called MCM Portfolio versus Hewlett-Packard, the U.S. Court of Appeals for the Federal Circuit, which is, as many of you probably know, is the Court of Appeals that exclusively handles patent cases and appeals from all over the country. The Federal Circuit upheld inter partes review against constitutional challenge, concluding that patents, although recognized for decades by the Supreme Court as private property, nonetheless involve public rights, disputes over which can properly be delegated by Congress to non-Article III courts, like the PTAB. That's so, the Federal Circuit reasoned, because patent rights are implicated in a federal statutory scheme and thus fall within the public rights doctrine. Again, a narrow exception to the general rule that disputes involving private rights can only be adjudicated by courts. MCM took the position that under the Federal Circuit's expansion of the public rights doctrine to encompass patent rights, again, which have long been acknowledged as private property, the very narrow exception created by the public rights doctrine would swallow the Article III rule, given the extent of indisputably private rights implicated by federal regulatory regimes, as WLF knows all too well. Less than a year ago, the Supreme Court denied review in MCM, along with two other petitions raising virtually the same constitutional issues. Enter Oil States. Briefly, by way of background, Oil States originally filed a patent infringement suit in federal district court against Greens Energy, a competitor. Greens, in turn, filed a petition for inter partes review alleging that the claims of Oil States' patent were invalid. This is a common tactic, I understand. Entities that have been accused of infringement go to the PTAB precisely because the PTAB invalidates patents at a much greater rate than district courts do. The petition for inter partes review was granted, the board agreed with Greens, and the patent claims at issue were invalidated, as happens in the vast majority of inter partes proceedings. To give you some perspective on that, since inter partes review became available in 2012, the agency has received nearly 7,000 petitions challenging patents and issued over 1,500 final judgments, the figure's likely higher now, about 1,300 of which have invalidated at least some of the challenge claims. Oil States appealed to the Federal Circuit, and after Oil States filed its opening brief, which raised, among other issues, the constitutionality of inter partes review, the Federal Circuit decided the MCM case, which foreclosed Oil States' constitutional arguments. Ultimately, the Federal Circuit panel ruled against Oil States without an opinion, affirming the board's judgment in all respects. In June, the Supreme Court granted Oil States' petition to determine the constitutionality of inter partes review 8 months after denying the petition in MCM. Oil States filed its merits brief in August, followed by roughly 30 amicus briefs, both in support of Oil States and a significant number in support of neither party. The response briefs are due October 23rd, with oral argument likely to be set for the December sitting. And to put the constitutional arguments in a practical context, several amici have pointed out that by some estimates, although inter partes review has only been in operation for 5 years, it's resulted in a 60% decline in the average price per patent in the United States, in turn resulting in a $1 trillion hit to the U.S. economy. That's not counting the economic value of lost opportunities, lost job, and disincentives to innovate. So in addition to the importance of the constitutional issues raised in the case, and particularly the separation of powers, the Article III issue, the practical free enterprise implications of the case are quite considerable as well.
Thank you all for having me here. I'm especially honored to be here with Andy and Allison, who I hold in extremely high regard. I was going to cover the securities docket, which has 3 cases on the court's docket this year, which is actually a pretty big number if you consider the ever-shrinking Supreme Court docket, which when I was a law clerk was 120. probably down from over 200 in Andy's days down to, I think, 70 or 60 sometimes these days. And I was going to start with Cyan versus Beaver County Employees Retirement Fund, which strikes me as perfect proof of what I call the waterbed theory of the law, which is you push down here and it pops up over there. And as anybody who's ever used a waterbed knows, it's impossible to get out once you're in. So for reforming class actions, Congress began pushing down with the PSLRA, with the Private Securities Litigation Reform Act back in 1995. And Congress and the PSLRA tightened pleading standards. It reformed discovery to address timing for discovery. It addressed certain perceived abuses in the class action context, in securities class actions in particular. But a lot of those reforms were procedural in nature and limited to actions in federal court. So you push down on federal securities actions, class actions in federal court, and what pops up are the same things that everyone was claiming about, but they're popping up as state court actions, state court fraud actions, in state court. So Congress, 3 years later, pushes down again. And it enacts what's called SLUSA, the Securities Litigation Uniform Standards Act. And Allison mentioned that everything has to have an acronym. And I'm going to just get on a roll for a moment here and say there should be acronym police at Congress. Because I don't know about you guys, but SLUSA to me sounds like something that just plain leaks. I mean, I have an old British car. And I think, the mechanic's going to call me and say, I'm sorry, Jeff, we had to replace the SLUSA. It just like coolant all over the floor of the garage. So, and that's a little bit of foreshadowing as to what this case is all about. Because SLUSA does at least two things. And the question is, what more does it do? It says, for covered class actions, Section 16b says, for covered class actions involving covered securities, plaintiffs cannot assert a state law claim, in essence, that could have been brought as a federal claim in federal court. So in essence, if you've just taken your federal claim and rebadged it as a state law fraud claim and brought it under state law, that's no good. That can't be maintained. And Congress provided a nice little hammer to enforce that, which is Section 16c, which says when a plaintiff does that, you can remove it to federal court. The federal court will dismiss out your state law claims. Done. Easy enough. So we're pushing down on those state law claims. And what pops up in state court, and what pops up? Sure enough, federal fraud claims, federal securities law claims in state court. Not those pesky state law claims that Congress quite clearly addressed in SLUSA, but federal claims, just in state court under concurrent, what potentially would be concurrent jurisdiction. And where does that trend start? It starts in California, the land that brought us the waterbed. And I checked on that, by the way. It really did come out from California. There was a design student named Charlie Hall in San Francisco, and sure enough. Anyway, so CYAN's all about whether the SLUSA allows those federal securities actions to be brought in state court. And shockingly enough, it comes down to a little tiny except clause inserted into a lengthy jurisdictional provision. So the securities laws originally provided for concurrent jurisdiction between state and federal courts for securities actions. And SLUSA adds this little phrase. It says, except as provided in Section 16 of this title with respect to covered class actions. And here's the conundrum. You look at Section 16 of the title, and it provides only one prohibition. And that prohibition is state law claims in state courts and doesn't talk about federal claims in state court. But we all know what Congress was trying to do in SLUSA. It's trying to prevent people from bypassing the federal limits and abuses on federal class actions by running to state court. And a little reading kind of leaves that except clause with almost no meaning at all. And so defendants come in, they say, well, no, when Congress said except as provided, they really meant except for the covered class actions as defined in Section 16. And this case is a real test for the court in a lot of ways. Not just whether or not they're going to let these actions go forward, which were the very actions that Congress thought were abusive. But it's kind of a textualist nightmare. We know what Congress was doing, but it did a really terrible job. And you just have to look at the SG's brief, the Solicitor General's brief, to realize how bad the job was. Because the brief starts out, and it's a lot of hammering. It starts and says, well, there's this one construction over here, and it's just horrible. Look, it violates all these principles of statutory construction. It says, but there's this other construction over here, and it's just awful too, and it violates all these principles of statutory construction. And as between the two, we're going to take the one that's least offensive. And it really, you feel like the Supreme Court, after looking at this, is going to come out with a new principle of statutory construction called the least offensive construction rule, which you go with the reading of the statute that is least likely to turn a textualist stomach. But if the court construed, and the other possibility is the court could go with what I call the Congress feet to the fire rule, which is sometimes I sense or I suspect the court is choosing the construction that's going to prompt Congress to act, because the court's always happy when the legislature is doing its job in legislating. And so there's a possibility that perhaps the court will read this narrowly in a way that I don't think anyone really thinks Congress meant, so that Congress steps forward and actually corrects the issue and does what it meant to do. Oh, but stay tuned. There's a jurisdictional question at the threshold, so it's also possible that a little bit like the SG, the Supreme Court will say, we can't figure out what this means. There must be a jurisdictional problem on the way, dismissed as improvidently granted. Turning to Digital Realty, which is the second case I want to talk to. It's Digital Realty Trust versus Summers. That's all about whistleblowers. It's more actually a case about who is a whistleblower for purposes of Dodd-Frank. It seems that whenever we have a scandal and a public outcry about in the financial sector, we always get legislation named after two sponsors. So we got Sarbanes-Oxley, and then we got Dodd-Frank. And lucky for us, this case involves both of them. So both of them make it unlawful for public companies to retaliate against employees for reporting alleged breaches of the securities laws. And the question in Digital Realty is, under Dodd-Frank, are you a whistleblower if you report their concerns to management, but not the SEC? The plaintiff in that case claims that he went to management with his concerns and was promptly fired in retaliation before he got a chance to go to the SEC. Now, helpfully for the defendants in this case, Dodd-Frank, and very unhelpfully for the plaintiff, I might add, Dodd-Frank not only has a provision that's talking about whistleblowers, but it actually defines who a whistleblower is. And it says, the term whistleblower means any individual who provides, yada, 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 information relating to a violation of the securities laws to the commission. Wow, you kind of want to stop reading there, especially if you just spent the last 30 minutes slogging through SLUSA. So a whistleblower is someone who gives information to the commission. If you gave the information to management and not the commission, you're not a Dodd-Frank whistleblower, QED, right? Not so fast, the SEC and the plaintiff says. Read the fine print. And when I say read the fine print, I'm talking about something in the US Code, not something that Andy or one of his clients stuck in an arbitration clause. So it turns out that Dodd-Frank's whistleblower protections have three different little categories. And the last one cross-references another statute, our favorite, Sarbanes-Oxley. And it says that you can't retaliate for people, quote, making disclosures that are required or protected under the Sarbanes-Oxley Act of 2002. And our friend Sarbanes-Oxley reaches out and protects disclosures to management, not just to the SEC. And sometimes it requires you to management. So when the conduct falls into that third category, the SEC has argued, and the plaintiffs argue, we should ignore the definition of whistleblower in Dodd-Frank and go and look by a Sarbanes-Oxley specific definition. And the SEC has a regulation that basically says that. And the practical impact of this is pretty significant in its own right. If an employee claims retaliation under Sarbanes-Oxley, there are very measured remedies. There's administrative exhaustion, a 6-month limitations period. He can get make-whole relief. But if the same person for an internal report can come back and claim under Dodd-Frank, there's much more expansive remedies. You can go straight to court usually, 6 years is your statute of limitations, and you can get double back pay. This case is possibly more telling, though, about how the court feels about agency deference. Many people in the Supreme Court bar have been getting the feeling that the Supreme Court is exercising its muscle a little bit, or feeling a little bit like it needs to push back on agency self-aggrandizement. In fact, Oil States is sometimes thought of as fitting into that category. And the feeling is that, look, the courts have the job of saying what the statutes mean. They say what the law is, and maybe we shouldn't be paying too much attention or as much attention to what the agency means. And one way to do that is to pronounce more statutes unambiguous. And another one is to overturn agencies when they don't really explain, they don't tarry with the language, they just sort of make up the rule they want. And there's an effort by the petitioner and the supporting amici in this case to exploit that sentiment and encourage a little judicial skepticism about the SEC's interpretation of whistleblower, which seems to depart pretty radically from the statute. So the final case on my securities law watch list is Leidos versus Indiana Public Retirement System. And that one actually has an argument date. It's going to be argued in November. And Leidos seems to be Well, everyone in Lidos agrees with a principle that every parent agrees with, and that is that silence is golden. The case really is all about, in cases of silence, who gets the gold, the plaintiffs or the defendants. It also involves, well, what is silence? Was the defendant really silent? And it tests the Supreme Court's attitude towards a cause of action, under 10b-5, that it created. The Supreme Court implied a cause of action under the SEC's rules back in the 70s, and how generous is it going to be in describing what it covers. And the fun part of all of this is, the case is at the Supreme Court and has its origins in an opinion that Justice Alito issued when he was a judge on the Third Circuit many, many years back. So the SEC requires issuers, when they're making certain filings, to include something through item 303 to provide a narrative of, quote, trends or any known demands, commitments, events, or uncertainties that could affect the issuer's liquidity in a material way. That narrative is called an MD&A, for management discussion and analysis. The defendant in Lidos is accused of kind of leaving something out of it. It didn't disclose under item 303 that it was subject to an ongoing investigation at the time that eventually resulted in a very uncomfortable deferred prosecution agreement and $500 million payment in restitution and penalties. And the question in the case is that omission in violation of item 303 actionable securities fraud under 10b-5? So when he was a judge on the Third Circuit, Justice Alito wrote an opinion in a case called Oren versus Stafford that's probably best characterized as answering that question with a resounding maybe. The Second Circuit and the Ninth Circuit both purport to follow it and kind of read that maybe in very different ways. And so now we have a case in the Supreme Court trying to figure out what the answer is. And swirling inside of this is a venerable principle that the Supreme Court has articulated many times, which is that pure omissions, silence, is not actionable, absent a duty to speak. The Second Circuit gets its hands on that and says, well, Rule 303 gives you a duty to speak. Item 303 says, there's these circumstances under which you're supposed to talk. You're supposed to disclose these uncertainties, these trends, these claims. And if you don't disclose them, you violated a duty. Now, you still have to meet all 10b-5 requirements. You have to just meet a more demanding materiality requirement. 10b-5 materiality is more demanding than Rule 303 materiality, for example. But sure enough, Rule 303, that will provide your duty. The Ninth Circuit and defendants, on the other hand, read a different part, or actually, quite frankly, a different sentence than Judge Alito's opinion, and says, you know, that duty to speak has to come from someplace other than an SEC rule. Because if you take the duty to speak from just an SEC rule, in effect, you're expanding the implied cause of action under 10b-5 to cover every single violation of the SEC's rules, regulations, and requirements. And the very fact that we're talking right now about a case that involved a violation of item 303, not item 2, item 7, or even item 29, but item 303 from the SEC's rules, kind of proves how expansive that liability could be. So all this, regrettably, could turn into a tempest in a teapot, though, because one possible source of the rule is when you do speak, you have a duty not to mislead by omission. Speaking selectively in a way that makes the statement misleading is actionable. And that's where the Solicitor General and that's where the plaintiffs put their claim in the case. They claim that, hey, you did disclose things under item 303. You did have your MD&A section. You just left this out. You implied by doing that there's nothing else material that you needed to disclose in this section. And they rely on item 303 for that. They say, well, an issuer that has an item 303 disclosure impliedly says, this is it, there's nothing else, I'm done, there's nothing else hidden out there. So in that sense, they actually come full circle and they end up relying on item 303 again, but in a different way. Even if item 303 doesn't provide the duty to speak, they argue, it makes an omission misleading because the reader expects your disclosures under item 303 to be complete. This is an important case because I think, like many of these cases, it sets the courts on a battle between two sets of values that it holds pretty dear. On the one hand, look, SEC regulations impose myriad disclosure requirements, and the court's undoubtedly going to be very concerned about turning many of those into private damages actions. And it's going to be especially concerned because all those private damages actions aren't anything Congress created. The Supreme Court itself implied a private cause of action way back in the 1970s, and it hasn't taken it back yet. On the other hand, this is an area where the court hasn't been all-embracing of strict categories. Omnicare and other cases suggest that the court's really been sort of resistant to air categories and sort of willing to look at things like misleading by omission in a very holistic, all things considered kind of way. And I would expect personally that we'll probably get an opinion along those lines here.
Okay, well, thank you, Jeff. Very, very interesting talk from all of you. Now is an opportunity for our live audience and our audience watching via webcast to submit questions to our panelists. If you're watching via webcast, there's a platform for you to submit your questions. So I will open it up to any questions we have from our live audience.
I have a question about the patent case. To what extent might the outcome affect the status of other departments and agencies, administrative law judges?
Sure, and I think the short answer to that is it really depends on how the court decides the case. In our brief, we've suggested an argument in a way for the court to decide the case that would really only apply to inter partes review. In fact, not even other proceedings kind of on the edges of that. So speaking for Oil States, our approach is a very narrow one, and I think given this court's tendency to really resolve issues before it quite narrowly, I would expect if the court goes that route that we'd see something along similar lines.
Is it your expectation, Allison, that you'll see something from the court taking a more firm position on the issue of agency deference in either of the respects that you mentioned when you were talking about the Oil States case?
I think what I would say to that is I think we're likely to see something from the court that at least acknowledges sort of the movement in Congress over the years in this area. I think primarily the court has looked at it in the context of agency interpretation of statutes, right? So it's the transfer of the judiciary to interpret the law. I think Oil States presents a similar, right, and Chevron deference. I think Oil States presents a related but distinct issue involving the transfer of Article III power to adjudicate cases, which again, I think it's part of the same, I think as Jeff said, it's sort of part of the same kind of atmospheric, but slightly different doctrine. So in other words, it's certainly possible that the court could either decide Oil States in a way, or as it did in mortgage bankers, regardless of how it decides the particular issue before it, it could nonetheless, through concurrences or the like, use the case to send a message concerning, I think it's growing unease, skepticism, whatever you want to call it, with the rise of the modern administrative state.
Yeah, and just to add to that, I think putting aside Oil States, I think it's pretty clear, especially with Justice Gorsuch's addition to the court, that things like certainly our deference are on the clock in terms of their continued viability, and that Chevron itself, which the court, even prior to Justice Gorsuch joining it, was moving away from, finding lots of statutory interpretation issues that for one reason or another were not going to fall within the Chevron bucket. I think you can probably expect that trend is going to accelerate as well.
And the court often finds other reasons not to defer. For example, we've seen this trend towards what people are calling the major questions doctrine. Too big a question, Congress wouldn't have meant to delegate it. This is a big issue, the court should decide it. It's not the type of interstitial thing that an agency should be deciding.
My question is for Mr. Lampkin. The Digital Realty case, it touches on what you were just talking about. How likely do you think the petitioners in the case cited to the violation of the Administrative Procedure Act and the fact that the SEC's rule was not the logical outgrowth of their proposed rule. And petitioners argued that Chevron shouldn't apply because of that violation. I just wanted to get your thoughts on that piece of the case, how likely it is the court will consider that, or if you think it'll be decided just on statutory interpretation grounds.
All right, so this is a shoot from the hip answer. I don't know what is going to happen. In all likelihood, though, I don't think that's going to be the rationale for the court's decision. It's an odd case in some ways because it's not on direct review of an agency rulemaking, so you don't have the agency there defending its rulemaking on the record. It is coming up in a different context where the agency is at most an amicus. And so my guess is this is going to be based on sort of substantive. The statute's clear, we don't know what the agency was thinking, and all the agency rulemaking violations are sort of in the background that have a tendency to do things like delegitimize the agency's perspective or undermine the credibility of the agency. My suspicion is that the court instead is going to go on statutory grounds alone. But it's a guess, and we'll know better from argument and best once the decision comes down.
Yes.
I also have a question about the arbitration case. To what extent do you think we might obtain some new guidance from the court on what you called displacement of one federal statute versus another, which compared to federal preemption of state law is quite scant? You think there'll be new law coming out of the decision?
It's certainly possible, although I think it'd be pretty easy for the court to decide this case based on what it's already said about the FAA in the context. The Federal Arbitration Act is one area where the court has several times addressed how its interaction with other laws should be addressed. So I think it's more likely to base its decision on that sort of FAA-specific guidance that it's already developed as opposed to moving off into something more general about interaction between two different sets of federal laws.
I have a kind of a follow-up question to what Larry was asking earlier about the possible impact of oil states. In particular, there's a circuit split, I guess, on the constitutionality of the SEC's use of administrative law judges. I'm wondering whether that will be likely to be affected by oil states, whether the court is likely to take up that issue this term, and what position the Solicitor General will end up taking, whether they will support the SEC on this issue.
Well, that petition is pending, and since the D.C. Circuit en banc split 4-4 on that question, and as a result left intact the panel decision, which conflicts with the 10th Circuit decision, I think it's highly likely that that case is going to get taken, putting aside oil states. I think this term could be very, very significant in terms of separation of powers issues. You have oil states, you have this Lucia case, which is the case about SEC ALJs. You have possibly coming to the court the question about the constitutionality of the CFPB's, Consumer Financial Protection Bureau's very unique constitutional structure, pretty much insulated from any elected official anywhere, which is now before the en banc D.C. Circuit, but I think there's likely to be a cert petition, however the D.C. Circuit rules. So I think you can see a whole bunch of issues moving to the court. And in fact, the court granted today a case about military tribunals that has an appointments clause issue in it. So I think there's just increasing concern with structural protections and a likelihood that the court will be addressing them in a very significant way.
I want to remind everyone online that you can ask questions if you have questions. There's a device right next to the screen that you can do so, so please ask questions if you have any. I have a question for the panel, which is, you have the unusual situation this year in the Jennings case of a case being re-argued before the court that's been previously argued. Be curious about your thoughts as advocates, what kind of strategies go into that process, what's different, what ends up being the same. Any thoughts on that I think would be very interesting.
Well, I'm happy to start, but other people should chime in. I think re-arguments are interesting. Some conventional wisdom is, well, a case is being re-argued because the court is split 4-4. Justice Gorsuch didn't sit when the case was first argued, so he's the deciding vote. Although if you look back at the history of re-argued cases, often the final vote is not 5-4. It's 6-3 or something else. So I think one thing is for the advocate not to believe that sort of everybody else's positions are locked in and it's really only the new addition to the court that's going to make a difference, or in some cases, a justice who was recused in a prior case. There was an issue in the copyright law about exhaustion, the first sale doctrine and international sales, in which the court split 4-4 originally, and then the final decision was 6-3. So I think you never know. I think, looking back at the argument and seeing the questions that justices asked and really thinking about what might have been behind them and trying to fine-tune those answers is another really important thing to do. And then stepping back from the argument as a whole and saying to yourself, although it's very hard to do, is there another way that I can frame this case orally that might lead justices to take a second look and see it more from my perspective?
I couldn't agree with Andy more. I do know that some folks like to think that they can psychoanalyze individual justices and make an argument to appeal to this one or the other. But in the end, especially on re-argument, my own strategy would be find the force of the better argument, go to that. You may have found a lot of weaknesses, because there are 9 or 8 of them for some of those cases, that they've really picked you apart. They've disclosed your weaknesses. What's the force of the better argument that's going to bring around as many of those votes as you can? I don't think it's a wise idea to try and pick out individual justices and get their votes. I don't think it works. I think they're all looking for the force of the better argument, and you got to find that yourself as an advocate.
If we have time for one more, I'll exercise the moderator's prerogative and ask that question myself. I was involved in an antitrust case about 10 years ago, where we prevailed at trial and then on appeal, and the FTC petitioned for cert. And we were very gratified to have the DOJ weigh in against the FTC cert petition. It doesn't happen all that often. And I'm wondering if you all have any observations about cases where a so-called independent agency like the FTC or the NLRB takes one position and then the government takes an opposing position.
Well, it's obviously an interesting situation. I think obviously it dilutes to some extent the force of both arguments as representing the government's view, since the government has a divided view. But I also think increasingly this is a court that certainly outside of maybe the national security context, maybe the criminal context, although even there not to some extent, is not really very deferential, putting aside Chevron and agency decisions, to the federal government's lawyers' view about how the law lines up in a particular case. So I think it really turns on the force of the arguments that the various agencies are going to make, as opposed to something magical about, one agency, the Justice Department, versus what an agency is going to say. Except to the fact that especially where the enforcement interest is divided, as in the antitrust context, it's awfully hard if the antitrust agencies are divided for anyone to seriously say, oh, it's so clear that the enforcement interest is on one side or the other.
It's an unfortunate optic, if nothing more, to have the government split against itself. And it's a particularly unfortunate optic when it results from the SG having switched positions. It just, it makes, you don't know who to take seriously or why in some ways. But I don't think it really affects the court. I just think it kind of is uncomfortable for everybody at the podium.
I'll just self-servingly note that dynamic was not present in my case. The government was not switching positions there, and I switched positions about 10 years later in a different case. But I think on that non-controversial note, we'll close and thank everyone for coming to watch us in person and via webcast, and stay tuned for the WLF's future programs on the court's docket. Thank you.